evening. You're watching The Urban Debate with me, Avni Raja. On the show tonight, I'll get you the latest developments combined with expert analysis on the day's top stories. Our top story, the controversial order by Kerala Sessions Court granting bail to a 74-year-old man in a case of sexual assault. The order cites provocative dressing and assumes a 74-year-old can't commit a sexual crime. We'll get you top legal voices to react. Also, putting the spotlight on Tamil Nadu politics, the Jaya legacy battle shows no signs of ebbing as the leadership tussle within AIDMK between EPS and OPS continues to take several twists and turns. Meanwhile, Tamil Nadu CM is in Delhi and met with Prime Minister Modi. And the conman Sukesh case sees another twist after being questioned several times by the Enforcement Directorate. Actor Jacqueline Fernandez named as an accused. All of those top stories coming up over the next hour. But let's begin with our top focus. In a controversial or rather blindsiding order, a Kerala Sessions Court has granted bail to a 74-year-old man in a sexual harassment case. Granting bail, the court has said that the offence did not stand when the complainant was wearing a sexually provocative dress. The court also observed that this activist is 74 years old and physically disabled and hence could not have forced himself upon the woman. Not just that, the court has also said that there was a long delay in lodging the FIR and the reason for the delay was not explained properly. And in this case, the FIR was lodged 2 years after the incident of crime. Listen to Vivek as he gets you the highlights of this order.
Now, the court has said that this offence will not, invite Section 354 of the IPC because the complainant, in this case, the victim here was wearing a sexually provocative dress, and hence, the person here is Civic Chandran, who is a social activist and writer, cannot be booked under 354A. Also said that how can a person of the age 74 commit a crime? He's got physical disabilities also. Remember, this incident took place in 2020, and how come that the complaint is filed in 2022? A FIR has been registered just 3 months back. Remember, this case has created a major wave and controversy, especially among various activists and in the cultural spectrum. A number of people have questioned the activist, but a section of activists and writers were also supporting Civic Chandran at one point of time, saying that the complainant is making a false charge. But the complainant is sticking to her allegation. She has said that in the 2020, in the month of October, in a camp, a poetry camp at a beach in Kozhikode, the Nandi beach in Kozhikode, that she was physically assaulted. There was sexual harassment that's been made against her, and hence she is sticking to her charge. But the court's comment today in the order, in the anticipatory bail order, which has been given issued by the court, this particular statement that the offence cannot invite 354A.
Well, joining me first on the broadcast is former ASG Pinkyanand. Thank you very much, ma'am, for speaking to us here on Mirror Now. Now, as far as this case is concerned, there are multiple issues here that have led to controversy, but the most glaring one, let's begin with that. This is the reference to sexually provocative dressing, because not only is there ambiguity in what constitutes sexually provocative, but if even that were to be overlooked, it still squarely places the blame on the victim, something that we as a society are constantly battling. What is your own view?
No, you're right. I mean, this constant effort of trying to put a kind of situation where you are identifying as to what a woman should do or how she should dress or not dress, or that the victim herself is a person to be blamed. It's a very typical victim blaming situation, which happens not only in matrimonial cases, but which happens more so in criminal cases. So this victim blaming really has to stop, and I think this victim blaming and victim shaming is something to be frowned upon totally, and you cannot put the blame on the head of the victim in any case, or the identification or characterization of how a woman should dress or not dress as if it's a domain of society at large, or for them to blame a person or the husband to decide what a woman should do or what she shouldn't do, or what she should wear or what she should not wear.
Yes, absolutely. And now the other problematic part, the order says it took 2 years for the complaint to be filed and that the delay was not explained properly. So when it comes to cases of sexual crime, from any court's perspective, should so much weightage be given to a delay in filing a complaint? And especially if we look at this specific case, under sections 354 and 354A, it does fall within the limitation periods for taking cognizance.
No, you're right, but ultimately, if you do recall that ultimately when it has been dealt with as far as the rape cases are concerned, as far as cases of assault are concerned, as far as 376 is concerned, which is also rape, as far as even DV is concerned, in most of matrimonial offences where allegations are made of assault or otherwise, it is literally deemed to be a continuing offence for the reason that it's a continuing relationship and the continuation of such attacks and assaults and remarks continues through the subsistence of such a situation. So delay by itself cannot really be a strong ground to defeat, because once you have it as a continuing offence, where's the question of it actually having a limitation, because this limitation would not apply. The law itself may prescribe a limitation for offences such as 354 which have up to 3 years, but the point is that the law itself also prescribes no limitation for a continuing offence such as this.
Right. Now, let's also come to the main assumption basis which bail was given that the court has cited, that a disabled elderly man could not have committed this kind of a sexual crime. For a court to make this assumption, especially when there is enough precedence and enough cases in the past where acts of sexual crime have in fact been carried out by those who are either aged or disabled.
All said and done, this whole assumption of the fact that elderly, aged, disabled, any of these categories of men cannot assault or cannot commit an act of sexual violence, I'm afraid is so misplaced in today's society, or any society for that matter. We have enough precedence on this, enough incidents of this, and there is no question of any disqualification or a bar of an aged or elderly or otherwise. Otherwise, even you see relationship, even that itself is considered as a ground. But in Indian societies, it has been very commonplace that people are known to each other. So each of these categories which are brought in to try to have the man escape from his liability are something which is an attempt to carve out a kind of niche for men to avoid liability under the criminal actions. Whether aged, young, old, middle-aged, disabled, any other category, invalid, you might find that history records instances of sexual abuse and sexual violence, and this can not be a ground to disbelieve or grant bail or any protection to the man in question.
Absolutely. In light of all that you've said, this is really not the first time that we've seen controversial judgments, especially from lower courts. And among the ones, which immediately comes to mind is the Bombay High Court, which held that skin-to-skin contact was necessary for establishing offence under POCSO. Of course, later it was reversed by the Supreme Court. But assuming that every time a higher court doesn't or can't step in, how dangerous a precedent can such judgments become?
No, you're right. It is very dangerous when you have precedents set in and you cannot have higher courts actually stepping in. You can't imagine a victim. A victim is having to go from one court to the other court. First, initiating an entire criminal process, then ultimately seeing that the criminal process goes forward, first having the gumption actually to go forward with the criminal complaint, and then the process forward, and then you have something which happens as a judgment from a lower court which you have to seek overturn of. I mean, this is actually pathetic, because at the first instance the message has gone down loud and clear from the highest court in the country that you cannot put in all these stigmatizations and characterizations. You have to take the victim statement at face value and believe the same to be true and credible. All these principles which have been laid down right from the Mathura rape case and others are the same principles. Believe a complainant when the matter comes in, unless there is reason and demonstration to show that you can't believe the complainant. In the absence of that, the complainant's version is the final version, particularly in cases of sexual offences, whether in matrimony or outside matrimony, in both of the situations. In such a situation, I think what we have to see is that we cannot expect all the time for the higher court or the Supreme Court to step in and say this is wrong. Of course, if need be, that is what happens, but it should not happen like that. And I think action must be taken against erring authorities which don't see the outcome of such situations. It's not only a black mark, not only the social media talking about it or the media talking about it, it's a public at large who's scandalized by such situations, and this is something that must be rectified at the first level.
Yes, so how can that be done? What is the solution here? What are the changes required, especially in the lower courts, because that's where we see some of these judgments coming in from?
I'm afraid one of the solutions is, of course, the higher court. But as we said and discussed, you can't have the higher court stepping into each and every individual case and finding a solution. You have guidelines, you have strictures which are passed against judges in the skin-to-skin contact. For example, action was taken against the judge in question. I believe, in fact, that you have to take stringent action against those violating the norms that have been laid down by the Supreme Court and by the law. And possibly we have to find some standard which we put into the code itself to ensure that particularly victims of sexual violence, if wrongful action is taken by the authorities or by the concerned lower court, so to say, action should be taken against such officials, not only in terms of reversal but also direct action as far as preliminary action is concerned or departmental action is concerned against them.
Right. Thank you very much, ma'am, for joining us with your perspective on this entire case. Let me also welcome Abha Singh, lawyer and activist, who's joining us, as well as Advocate Namit Saxena. Thank you so much, both of you, for joining us on this issue. Abha Singh, let me start with you. Your perspective here as far as this entire case is concerned and what the court has said.
I was listening to Pinkyanand, and here I would like to say, because this offense had happened 2 years back, the law is very clear that when you come to register an FIR or you register an offense, it should not look like it is an aftermath. Because there's been a 2-year gap, the opposite side would say that it is an afterthought. So it is important that they say when you are registering your complaint, you should be able to convince and tell the fact that why you've been delayed. So this victim should have a very plausible ground to show that why it was delayed, what had happened, what were the reasons, whether she was scared or there were some problems, or she went to the police again and again, they did not register her complaint. So she will have to substantially explain at the time of trial, explain to the court that why it was a delay. Otherwise, this is the reason that so many of these cases, the accused goes scot-free. If you see in the case of rapes, the conviction rate is barely 29%. In molestation and all, it is even less. So what is important is that she should be able to explain that why she kept quiet for 2 years. Then another point which is very important here is that this person is disabled. So the court says this, that how would he do that and how would he bring her on her lap? So these are the questions which is very important for the police to investigate, file a foolproof charge sheet so that this stands in the court of law. Yes, the court has definitely erred when it says that the victim was wearing a provocative dress. Here I would also like to point out that so many times people say they blame these sexual offenses on the type of clothes women wear. But then the question arises, what happens when girls as young as 6, as young as 4 are raped and molested? What is their fault? They are not even built that way, or they're grown, or they're wearing any clothes like that. So crime, one has to be very clear that it is a matter of law and order. It cannot be connected to a woman's character or to the clothes she's wearing. So I think this part of the order needs to be expunged. It needs to be struck down, and I'm sure it would be struck down, as in the case of Justice Pushpa Ganeriwala, her judgment was stepped aside and she lost her position in the High Court. I'm surprised that even in today's world, such type of patriarchy exists in the judiciary, that a judge, while writing an order, while giving the accused bail protection, okay, fine, you want to give him a protection of bail because he's old, because he doesn't have a past criminal record, or because it's an afterthought or whatever. But to write this line that the victim was wearing a provocative dress, I think it's a dark day in the history of women's rights. It's a dark day in gender justice, because this has thrown women back into the dark ages. Because whenever now a guy will molest, say, oh, you were wearing such dresses, you were wearing a dress which showed off your cleavage. So I think it is necessary that this order is set aside and the judiciary.
Yes, absolutely, Abha Singh. I completely agree with you. Let me also bring in Namit Saxena as well. Your perspective here, given that it's not just 1 or 2 issues, it seems to be a whole host of issues and problematic aspects that have been cited by the court.
See, firstly and foremostly, observations in a bail order do not affect the trial at all.
Okay.
Whatever observations in a trial or in a bail, in bail, the observations made, they are not, any from any stretch of imagination, they affect the trial at all is one. Second, the bail has been granted on a lot of factors, including the age of the accused, physical disability of the accused. There is an inordinate and unexplained delay in lodging the FIR. See, at the stage of anticipatory bail, you evaluate whether custodial interrogation of the accused is required or not, or whether he is a flight risk, or whether he run away from, or if there is tampering, if there is chance of tampering the witnesses or evidence at all. So these are the factors which you weigh at this stage of anticipatory bail. Now, all this the trial court has considered. Third, what the trial court says is that there were a number of people who were present at the alleged time, at the alleged place of incidents, and nobody has come forward to say anything. Nobody's evidence, nobody's statement has been recorded. Fourth, what the trial court says is that the daughter of the accused is a deputy collector, so they cannot be you can't rule out possibility of false cases because there is an inordinate delay of 2 years, because the allegation is that there are enemies who are at picture, and this can be a planted case. Finally, so we don't know if there is a pressurizing tactic this case has been planted at all. One. Now, second, we have a settled law that a person is innocent until proven guilty after trial by a competent court of law. And finally, we also know that bail is the rule and jail is the exception. Now, coming to the observation made by the trial court, I have a very strong opposition on taking those photographs on record one. See, these photographs which were shown to the trial court were handed over from some social media accounts of this prosecutrix, which may not be connected to the alleged incident at all. So these observations are bad in law. These observations, these documents, these photographs could not have been taken on record at all. This is completely against how criminal procedure works. So my perspective broadly on this is this, that as Mr. Abha Singh also pointed out, that these observations should be expunged, but on grant of bail, anticipatory bail more particularly, I think the order should be sustained. But these observations, on sexually provocative dresses, etc., these observations, although these are the observations, but even then these observations, and they don't affect the trial, but even then these are unnecessary to decide anticipatory bail in my view.
Yes, absolutely, Mr. Saxena. And that is really the point here, because the main issue is with these observations, citing something as sexually provocative, something that is so ambiguous, and something that as a society in terms of victim blaming is something we are really always trying to battle. So for a court to make such observations, the damaging effect that it can have going forward in other cases, victims may not feel comfortable in coming forward if they feel that we might be victim blamed in such cases. That is the real issue here.
See, the Sessions Court is not a court of record. So this judgment, this order anticipatory bail carries no precedential value at all. Okay. This cannot be treated as a precedent, because the courts of record are only, constitutional courts like High Court and Supreme Court, and their orders can be relied on and carry persuasive value also. But this anticipatory bail order by the Sessions Court has no precedential value. Based on facts of a particular case, this cannot be used as a precedent anywhere. Is one. Second, as I said, these observations may be expunged if the complainant challenges it, or the state can challenge it, or in fact the High Court can take it suo motu also and say these observations are irrelevant to the case and we are striking them off. But I think bail should be sustained. Bail has been granted rightly to this man because this is a case of anticipatory bail. Because if you'll see that order in para 6 says, and I'll read it out in just a small two-liner. It says, here it is to be noted that the de facto complainant is an educated lady who is fully aware of the consequences of sexual assault. Why she was reluctant to file the complaint has to be explained by her. But absolutely no explanation is forthcoming. So after 2 years, because the alleged incident is of February 2020. So if she has to say that, due to Corona, due to COVID, I couldn't come because lockdown was imposed in March 2020, or I was, scared, or whatever reasons she has to give, but there has to be a reasoning. It can't be that after 2 years we just come and say that that this happened way back with me in 2020, because the evidence is lost by then. So that is why perhaps this weighed in favor of the accused. Okay. That there is an inordinate and unexplained delay.
Okay, Abha Singh, but isn't that the reason why there is a limitation period for taking cognizance? And in this particular case, you have, like I was asking Pinkyanand as well, Section 354 and 354A, and this does fall well into that limitation.
That is fine for limitation, but when FIR, what does FIR say? That you bring to the notice of the police that an offence has taken place. So when will that be? The moment an offense happens, you are supposed to go and lodge that, give that information to the police. So yeah, it's not about limitation. It is about a crime which is happening. So you can't sit over a crime for so long. And in case you've sat over that crime, you have to give the reason. What the law also says that the gap between an offense happening and the complaint coming to the police has to be justified, that why it was what like that. It should not be an afterthought that somebody has propped you up to register that complaint. So that fact has to be taken in record, and that is where it is saying. Also, what is important here is that the woman, as they say, is educated. And 354A, usually you see in these cases, bail is granted because it's not rape, it is not a heinous offense. And usually, I mean, if you go by the track record, a lot of these cases, bail is granted. Bail, when you don't give bail. You don't give bail if you feel that the person may abscond. Now, this person is old, he's on a wheelchair, he's not going to abscond. And the second point which the court looks into is whether it can destroy evidence. Now, if there is no evidence after 2 years, what evidence can be destroyed? These are the only two grounds where when bail is granted, is looked into, whether you can destroy evidence, you can influence prosecution witness. I don't think, because on that ground, the bail has been rightly given. But the point which has been noted by the judge, that needs to be expunged, because it shows women in very bad light, and especially the victim, because somewhere her character you are assassinating by saying that she wore provocative clothes.
Yes, absolutely. Fair enough. On that note, thank you very much, both of you, for joining us with your perspective on this case.
Thank you.